Generally, professional sports are subject to federal antitrust statutes, such as the Sherman Act. However, professional baseball has historically been exempt from antitrust law. In the 1972 case Flood v. Kuhn, the United States Supreme Court reconsidered whether baseball was exempt from antitrust law in a suit brought by a former star outfielder of the St. Louis Cardinals. In 1956, at the age of 18, Curtis Flood began his Major League Baseball, or MLB, career for the Cincinnati Reds by signing a contract that paid him $4,000 for the season. At the time, within all MLB players' contracts, including Flood's, was a so-called reserve clause, or a provision that precluded players from negotiating future contracts with anyone but their current team. In 1958, Flood was traded from the Reds to the St. Louis Cardinals. For the next 11 years, Flood rose to fame as a center fielder, compiling a .293 batting average, 3 All-Star appearances, 7 Gold Gloves, and 2 World Series titles. But in October of 1969, at the age of 31, Flood was traded to the Philadelphia Phillies in a multiplayer deal. Flood wasn't consulted about the trade and received notice by phone after the deal had been consummated. Following the trade, Flood refused to play for the Phillies and instead asked MLB's commissioner, Kuhn, to declare him a free agent and allow him to sign with a team of his choice. In response, Kuhn refused, citing the reserve clause in Flood's contract. Subsequently, Flood sued Kuhn in federal district court, alleging, in part, violations of state and federal antitrust law. In particular, Flood argued that baseball's reserve system, which didn't allow players to negotiate contracts with other teams, was an unreasonable restraint on trade. Following a bench trial, the court found for Kuhn, concluding that professional baseball was exempt from state and federal antitrust law based on established precedent. Flood appealed the decision to the Second Circuit, which affirmed. The United States Supreme Court granted cert.